Here in Massachusetts, judges can order that a person with severe drug or alcohol addiction be committed to a stabilization facility for compulsory treatment. This is known as a Section 35 commitment because it's done pursuant to Mass General Law, Chapter 123, Section 35. So in the majority of cases when this happens, it's most often a family member of the person who has the addiction who files a petition with the court, and it's a standardized petition that you can get at the clerk's office, asking the judge to commit the person. Right? So in most cases, it's a parent asking that their adult child be committed. Maybe it might be a spouse or some other close relation, but in the vast majority, I'd say it's parents. Now, what happens is there's an initial hearing with the petitioner and the judge. The judge will look at the petition and see if there's justification to have a hearing on the potential commitment. And the judge will ask the petitioner whether the court should send a summons, a written order for this person to appear, or whether a warrant is necessary, where the police are authorized to go and arrest this person and bring the person before the court. Now, in the vast majority of cases, the petitioner will say a warrant is necessary. So the court won't send a summons. They'll just send the police out to pick this person up. Now, with these warrants, they are unique. They're different from typical arrest warrants. They're referred to as sundown warrants, and it says right on the warrant that the warrant expires at 4:30 on the day it's issued. Right? So if the police encounter this person with the substance abuse problem 5 or 6 o'clock, they can't arrest the person and hold them overnight and bring them to court the next day. Right? The arrest has to be made before 4:30, and it says on the warrant that the arrest should not be made unless the person can be brought to the court for hearing prior to 4:30. Right? So it expires at 4:30, and the court wants the person there ahead of time so that they have time to have the hearing before the end of the day. Now, it also says on the warrant that the police don't necessarily need to bring the person to the court that issued the warrant to have the Section 35 hearing. Although it says that, it's extremely rare for police to bring the person anywhere but the court that issued the warrant. And the last thing to keep in mind, if you're filing a petition for a Section 35 and you tell the judge that you want a warrant to have your family member or your loved one picked up by the police, you're setting up a confrontation between that person and the police. Now, in most cases, people just go along and cooperate with the police. But if they don't, you can guarantee that this person is going to be charged with resisting arrest, if that applies, disorderly conduct, if that applies. If the person has anything illegal on him or her when the police place them under arrest or put them into custody, they're going to be charged with possession of a drug or a firearm or whatever it may be. Right? So there are unintended consequences when you set up this situation where the police encounter your loved one or your child or whoever it may be to bring them to court for a Section 35 hearing. I've written a blog post on this, and I'll put it in the description below.